we're going to turn to the very, very important practical question of cost in arbitration. And I'm looking forward to hearing from Joseph Huse of Newton Arbitration on that subject. So over to you, Joseph.
Now, good afternoon, ladies and gentlemen. If I could first give you a little bit of background to me personally before I get into my topic. I was a partner at a Magic Circle law firm called Freshfields for about 20 plus years. During that time, during that entire time, I was part of what was called the International Arbitration Group. I retired as regional managing partner for RENA, and I helped to take a lot of money from a lot of different clients during those 20 plus years. Towards the end of my tenure at Freshfields, I also acted, and I continue to act as an arbitrator. I act as an arbitrator with respect to ICC arbitrations, LCIA arbitrations, and I also act as an arbitrator at the DIFC-LCIA, or what used to be called the DIFC-LCIA Arbitration Center. Since that time, I've had the great pleasure of working in a couple of different roles. But the role I think of most interest to you here today is I've acted as the group general counsel to a company in Bahrain called Noga Holding. Noga Holding, along with a company called Mumtalakat, is one of the two sovereign wealth funds in, if I can use that term, in Bahrain. Noga Holding has, amongst other things, the pleasure of having 100% of an NOC called BAPCO, so I also act as the group general counsel for BAPCO. And in this slightly different role, I have the pleasure of trying to control costs in arbitration. So that has given me the ability to try to think through how the arbitration process should be carried out. And what I'd like to do today is share with you a little bit of that thinking, a little bit of that experience. Before I get into to the presentation, I'd just like to say that my mentor at Freshfields was a gentleman called Jan Paulsen. Jan is probably one of the premier consuls and arbitrators in the arbitration world. He recently founded a law firm called Three Crowns. I had a conversation with him when I was a slightly younger lawyer at Freshfields. And I said to him, Jan, given your incredible background and experience, how often would you say that you win arbitrations? Jan's answer was somewhat surprising. He said, Joe, it's probably 50-50. I said, Jan, come on, 50-50, why is that? He said, by the time an arbitration gets to the point where we get hired, it's usually a case that's pretty difficult to solve. And if it was clear one way or the other, it probably wouldn't be an arbitration. So, Joe, it's 50-50. The purpose of my talk today, and I've given you a rather aggressive title. It's called a strategy for success. It's to make sure that in the arbitration process, not that I can guarantee that you'll win the arbitration process, but that I can hope that you can manage the arbitration process properly so that you can at least keep the 50-50 odds. Okay, so the second title, or the subtitle, is Achieving Value and Efficiency through Proper Management of the Arbitration Process. And I'll try to talk a little bit about a number of issues, including costs. So, what I'll do is my first point is that the arbitration process is complex and it requires specialist management skills. Second is that, and this is a great numbering, I don't know what happened to the numbering, but my apologies. The most common methodology for the conduct of arbitration is now turnkey, and that's where the company outsources the arbitration, including its management, to an international law firm. The third is that the use of the turnkey methodology may result effectively in application by the client in respect of key arbitration decisions and possibly with resultant value leakage. There is, however, a relevant precedent to how I believe these arbitrations should be managed, and that is if I look at the management of turnkey projects, in particular in the construction industry, I think there's a pretty good parallel that we might usefully apply to arbitrations. In particular, the need for arbitration management services as one strategy for success and to bring value and efficiency in the arbitration process. And last but not least, as a postscript, because I think as clients you'll want to see this, I'll talk a little bit about what I've entitled flexible structures for legal fees. And my apologies to the lawyers in the room, the outside lawyers in the room. Okay, let's go. The first is a quote from a project management book called, and this is totally appropriate for Joe Huse, Project Management for Dummies, right? The more thoroughly you plan and manage a project, the more likely you are to succeed. I've changed that slightly. I've taken a little bit of liberty with that quote. And I now say, the more thoroughly you plan and manage the arbitration process, the more likely you are at least to maintain those 50-50 odds that Jan Paulsen referred to. Arbitrations in the main have become complex, expensive, and lengthy. Legal fees alone can run into a multiple of millions of dollars. So the law firms are making a fair amount of money on it. They're spending a lot of time on these things. We can have an arbitration that lasts up to 2 years or even longer. And the team that is being pulled in play for the arbitration will include management inside the party, and also possibly an international law firm, maybe local counsel, oftentimes a barrister if the international law firm does not want to engage in advocacy, subject matter experts, and also possibly an e-discovery firm. In the turnkey model discussed, that I will discuss a little later, the parties will most often choose a key partner in a law firm who is probably a good lawyer and perhaps an expert in arbitration to manage this process. However, I ask you, is it always the case that a good lawyer, and I put myself in the category of a good lawyer, is a qualified manager with the right skill set properly to motivate a significant team of diverse individuals, or driven to achieve the highest efficiency in the workings of the team, including on-time performance of that team, and also the proper control of costs? Because as inside counsel, you are being judged in part on the costs that you are paying in connection with that arbitration. And it's a hard judgment for you as inside counsel to make. On the one hand, you want to win the arbitration, right? So on the one hand, there's part of you that says, I will pay any costs that I have to pay to win that arbitration. But on the other hand, every month those bills are coming in, and you have your CFO saying to you, in my case, Joe, why are we paying X law firm $300,000 a month? That's an extraordinary burn rate. Okay. Let's now look at some of the arbitration models for or some of the models for the conduct of the arbitration that are available to the in-house counsel. Right? The first is a resource model that is carried out completely with internal resources. So assuming that we have sufficient and appropriate internal legal and other resources, the general counsel may decide to undertake the arbitration using only the resources of the legal department. So the first model is do it all in-house. The second model is a model that is partially using internal resources and partially using external resources. So if we assume sufficient and appropriate internal and other resources, internal legal and other resources, the GC may decide to undertake the arbitration using a combination of internal and external resources. And even if that GC has sufficient internal resources, he may be forced to hire outside experts, either because there's a particular technical issue requiring independent technical advice or expertise, or, for example, if there's a legal issue of, for example, local law. The third possible model for the conduct of the arbitration is where we, as internal counsel, outsource all of the arbitration. Two possibilities in this respect. The first possibility is the party hires individual actors for the purposes of carrying out the arbitration, enters directly into a contract with the international law firm, with local counsel, possibly with a barrister, possibly with experts, and possibly with an e-discovery firm. But what do we usually do? We usually outsource the conduct of the entire operation, of the entire arbitration to a law firm. And today we've seen a number of representatives of very good law firms like Fenwick, like Clyde & Co., etc. They generally do a pretty good job. However, a party to an arbitration that's being conducted on a turnkey basis will be faced with numerous issues that arise in connection with the process. And I'm going to talk about a few of them. Many of these issues, if resolved incorrectly, may result in additional payments to be made by the party, and may affect the chances of winning of that party. Okay? And one of the questions that I've grappled with is, if I'm faced with a law firm giving me advice, talking about a particular dispute, do I have confidence in that law firm to give me the right advice with respect to the dispute? And my apologies, I can see some smiles in the audience. But so, first issue is, if you have a dispute, do you take it to arbitration, or do you kind of sit on it? Do you continue to negotiate, try to resolve it, right? Hopefully the lawyer is good enough to say, I don't care about the fees. I don't care about my position in the law firm, right? But, so one question for clients, and that is, do you go to that outside law firm to get the right advice about starting the arbitration, or is there other possible sources for that advice? Okay. Another question, another key issue is the extent to which an arbitration can be handled in-house. Okay? If you decide to go outside, if you decide to start the arbitration, how do you choose the right law firm? Are certain arbitration law firms better than others at certain types of arbitration? For example, construction disputes. I would suggest the answer is of course. Here's a really difficult one for in-house counsel. What fee arrangements are appropriate for law firms? Should a success fee be considered in whole or in part? How does a party review the invoices of a law firm? Right? I was asked last year by one of my clients to take a look at an invoice that had been issued by a law firm. It concerned 1 month. It concerned a very substantial litigation. When I did the numbers on the invoice, I counted up that there were well in excess of 20 lawyers that had been involved in the litigation during the first month. My suggestion to my client was probably 20 lawyers was inappropriate. They probably could have done it in a more lean and mean fashion. Why is that? Why is, as a partner in a good law firm, I put that many lawyers on a file? It's because I want to do the right job. Am I managing the file properly? Maybe yes, maybe no. Okay? A couple of other issues. What should the team look like from that law firm? Should it be a partner and 4 associates? Should it be 2 partners and 10 associates? Think of the differences in costs between a team of 5 and a team of 20, right? Is the team of 20 more efficient? Is the team of 20 going to do a better job? Not obvious, right? But again, as the client, you have to be exercising a lot of control over the process, right? You want to win, but you want to win at a reasonable cost, okay? Another one, how should the party appointed, let's assume that you start the arbitration, right? You've got an arbitral tribunal of 3 members. You're going to appoint one of the members. Your law firm comes to you and says, I think it should be Mr. X. Do you simply say yes? Do you get into the process with him or her? How do you choose your party appointed arbitrator? The two-party appointed arbitrators are appointed. They then come to you with a recommendation regarding a chairman, right? How do you decide whether or not that chairman is an appropriate chairman for your case, for your arbitral tribunal? Do you control that decision, or are you simply sitting back and letting your outside counsel make that decision, right? And how is he or she making that decision? Probably in most cases very well, but how do you know? Right? Okay. Same thing, expert advice. How do you choose when expert advice is required? How do you choose the expert? What questions should you be asking? Another question, how do you exercise quality control over the process? You're so busy, you've got so many things to do. Outside counsel is giving you a brief that's 200 pages, right? Do you review it? Do you go through it? Do you carefully consider it? Do you give it? Do you delegate it to somebody? How do you exercise quality control over the process? Okay, I'm going to give you just 2 slides here with respect to choice of outside counsel and choice of outside expert. These both come from a PwC survey that was carried out in 2013. As you can see, let's take a look at the 4 top ones with respect to choice of outside counsel. 93% says past experience of the firm or lawyer in contentious matters. It's a pretty reasonable basis upon which to decide. 88% say personal knowledge of the individual lawyer. Is that a good basis? It's my friend. Right? Recommendation by other in-house or outside counsel. They're friends. Right? Is that a good way to choose? Past experience of the firm or lawyer in non-contentious matters. Who cares if he or she is good in non-contentious matters? I want the best with respect to contentious matters. So choosing outside counsel is not easy. How do you choose an expert? 98% responded reputation. 88 said prior experience of giving evidence to the tribunal. That, for me, is a really big one. If that expert is not used to giving evidence before tribunals in courts, you can get fried. Have you ever seen somebody crumble on the stand, become incoherent, start to mumble, right? And you watch your case disappear in the dust. Right? So this is oh so important in getting this right. Okay, what do I do, right? How do I decide? How do I get help for this? Right? Well, I am in part a construction attorney, right? So I wrote a book called Understanding and Negotiating EPC and Turnkey Contracts. That's not a plug for the book. It's just simply to say I've got a little bit of construction experience behind me. I cut my teeth on Eurotunnel many, many years ago. But what do we do when we hire a turnkey contractor in the construction industry? Do we supervise these guys by ourselves? The answer is, of course we don't, right? Of course we don't. We get help. We get a PMC. We get a Wally Parsons. We get someone like that to help us undertake the process. I would submit to you, maybe it's time for us to start thinking about doing the same thing in the arbitration process. Okay, so under all the models discussed above that I've gone through with you, there's always going to be an extensive component of supervision for the legal department. Certain legal departments have the resources to carry out such supervision. Oftentimes, the legal department does not. I would aggressively suggest that most of the legal departments here in the region do not have the right resources properly to manage significant arbitrations. I would suggest that it's time to consider the possibility of something that I would characterize as an arbitration management service provider, so that they can help you get the right team to utilize the right tools for the right price, right? And the effect of such appointment should be to bring value and efficiency in the process. That is, more effective pleadings at a lower cost. Now, I can't let you not have a discussion on costs and arbitration. This pie chart comes from an ICC report in 2007, but I think it's equally applicable today, right? And remember that duality that I talked about. As a client, you want to win the file, you want to win the arbitration, but at the same time, your management is all over you telling you to cut the costs, right? So you want efficiency in the process. what is the number one cost in the process? It's not the arbitrator's fees and expenses. It's not the administrative expenses of the ICC, the LCIA, or the DIFC-LCIA. It's the party costs. What are the party costs? Primarily 2, maybe 3. The first is management time. I can't do much about that. The second is experts. My view is that generally experts, the cost of experts are pretty reasonable. How can we control their costs? The first thing that I would suggest in terms of controlling the cost is making sure that we have the right team, right? So anytime that I deal with an outside law firm, what I say is, who is it going to be? Number one. Number two, I try very hard to avoid scope creep, right? So what I want to see is I want to see one really good partner, and I want to see a team of 3 or 4 really good associates, right? And then I don't want to see it go from 1 partner and 3 associates to 2 or 3 partners and 10 associates. Not that any of the law firms in here would do that, but some other law firms not represented here might do that. All right, so I want to control the team. I want to make sure it's the right size, and I want to make sure that it's populated with the right people. And if anybody else is going to come onto that team, I want to approve it before it happens. The next thing I want to see is I want to see very, very detailed invoices. Right? Every entry has to be specific. Every entry, to the extent that it's a significant entry, should be broken down by time. And there's certain things that I don't like to see. Oftentimes I don't like to see travel time. Oftentimes I don't like to see too many internal meetings, although internal meetings are necessary. Let's take a look at this chart. First and foremost, if you're not having simply hourly rates, what is the leading, according to this survey of PwC in 2013, what is the leading methodology? It's capped hourly fees, right? How do capped hourly fees work? You can do it daily, most people don't. You can do it monthly, that's oftentimes a choice, or you can do it yearly, right? So for example, I would say to a law firm, this is your team, what's the monthly burn rate? And we go back and forth on the monthly burn rate, right? And we come up with a number. Or we say, let's budget for this process and let's think about what's going to happen over the next year, right? Tell me what's going to happen over the next year. Tell me how much time and effort you're going to have to spend on it, right? And then let's come up with a budget. I'm sorry, did I say budget? I meant to say a capped fee, right? Okay, what else do we have? Discounted hourly rates and a success fee, calculated as a percentage of the damages awarded or recovered. Discounted hourly rates and a success fee calculated as a percentage of your outside counsel's hourly rate. Other, and a tiny percent pure contingency, okay? And that is my speech. So thank you very much for your time and patience, and enjoy your lunch.
I thought when Joseph was telling the story of how many arbitrations have you won, I thought she was going to give a different answer, which is the one I always give. That may be why I thought it. You never win or lose in arbitration. You simply try to box above your weight. And that means that if you have a good hand, you want to play it well, not giving the other side any ground, and without making many mistakes. And if you have a bad hand, you want to play that as well as you can to get your client out of there without having to write a check for a larger amount than what he or she otherwise would. What you don't want to be is the kind of lawyer, however you're remunerated, who ends up being the lawyer that plays a bad hand badly.